Good afternoon, everyone, and welcome to another Gibney webinar on immigration matters. We're delighted that you've joined us. My name is Philomena Lepore, and I'm a partner with Gibney's Immigration Practice Group, and I'll be moderating today's discussion on intracompany transfers of essential personnel. I'm pleased to be joined by my colleagues, Mark Kingstone and Maria Mejia Opachu, both senior counsel within our Immigration Practice Group, who will discuss the visa used to transfer intracompany personnel into the U.S., known as the L1 visa. I'm also joined by Deborah Davey, who heads Gibney's Global Immigration Practice, and who will take us on a whirlwind tour to look at considerations for companies transferring intracompany personnel to selected countries worldwide. Now, as many of you listening may know, intracompany transfer visas are used by multinational employers when they need to transfer key employees from their offices abroad to their offices in the U.S. or vice versa. Though these visas are designed to facilitate global mobility and international assignments, they can often be rife with unexpected challenges that thwart their very purpose. Such challenges might include government delays due to suspicions of fraud, disparate government adjudications, concerns regarding dependent family members, and last and certainly not least, the ubiquitous request for evidence, or RFEs as we call them. RFEs in particular have posed an increasing challenge on the U.S. L1 visa front. They are being issued in record numbers. For example, 50% of L1B petitions and 40% of L1A petitions filed with the California Service Center are subject to RFE. RFE rates at the Vermont Service Center are slightly lower at 40% for L1Bs and 30% for L1As. From my point of view, and I'm sure for many of you listening, these are staggering numbers which have made the L1 visa daunting territory where it once was not so. So today's speakers will provide a basic overview of intracompany transferee visa requirements, and then they'll comment on many of today's challenges and offer some tips and best practices for tackling them. Throughout the discussion, please feel free to enter your questions onto the screen, and we will try our very best to answer them at the end of the presentation. If we don't have time, we'll be sure to respond to you individually via email. So without more, let's begin. Mark is going to start us off with the basics of the L1 visa category that's used by companies to transfer foreign national employees into the U.S. from offices abroad. Mark?
Thanks, Phil. Good afternoon, everyone on the East Coast, and good morning to those of you on the West Coast. Thanks for joining us. So I'm going to lead off the discussion of the L1 visa for inbound transfers to the U.S. The L1 visa permits qualifying multinational companies to transfer qualifying employees into the U.S. on a temporary basis. So what's qualifying? For the U.S. employer, qualifying is defined by its relationship with an organization overseas, and that entity overseas has to be either a parent company, a subsidiary, a branch office, or a 50-50 joint venture. In addition, the U.S. company can be a subsidiary or a branch office of the foreign company. Both organizations must conduct business actively all through the period of the beneficiary's L1 visa stay. Now, this is a particularly important point for entrepreneurs, startups, closely held companies, family-owned companies, because the L1 visa cannot be used to simply relocate a business from overseas to the U.S. It's not a way to establish a beachhead and then bring your business over here behind you. There always has to be ongoing activity abroad. And who's a qualifying employee? Basically, someone who's worked for the organization abroad for at least one full continuous year within the last 3 years. 2 prongs here. One is the continuous year. Bear in mind that you have an employee who may be making business trips to the U.S. during that qualifying year. That won't actually break the continuity, but it will stop the clock. So they do have to actually accrue the 365 days overseas. And if that means they've spent 6 weeks here in the year, then you've got to add those 6 weeks to the end. In terms of the 3 years, that's a bit of a gift from the agencies, because what they're saying is you may have an overseas employee who actually resigned a year ago, but had accrued the full 1 year before doing that. That person will then still qualify today for an L1 visa, even though they haven't worked for your international organization for a year.
And Mark, if I may interject just for a sec. So let's say that I really need to transfer an employee to the U.S. ASAP. Would we be able to apply for the L1 visa in advance of that 365 days?
And the short answer to that, Phil, is no. We can work with you as our clients to prepare all the documentation, but U.S. Immigration says that you're not eligible for a benefit until you're actually qualified to receive it. So that full year has to pass before the paperwork can be submitted. So let's look at the L1 in more detail. It breaks down into 2 classifications. The L1A for executives and managers, which confers a right to be in the U.S. for up to 7 years, issued in increments of 3 plus 2 extensions of 2 each. And the L1B for specialized knowledge employees, which confers the right to be in the U.S. for up to 5 years, also conferred in increments of 3 and 2. Bear in mind as you're strategizing that it's not enough only to look at the U.S. role in this analysis. The employee will have to fit into one of these categories both overseas and in the U.S. when you present the paperwork. So what do they break down into? Briefly, the executives, probably the one you're going to deal with the least, they're the ones who direct the management and set the goals and policies of the organization. Very senior-most tier. The most useful of the L1A categories is the manager. Managers in general manage some component or division of an organization and this is the key test, exercise discretion over the day-to-day operations of the component that they manage. They must have a degree of independent decision-making authority. Now that applies in either one of the 2 scenarios into which the L1A manager can be further broken down. One is the manager of staff, an individual who supervises not only the work of other professional or managerial employees, but also has authority over personnel actions relating to them. Or, the most controversial within the L1A, the function manager, who manages an essential function. We know that sounds a little bit circular, and I'll come back to that explanation, and who functions at a senior level with respect to the function managed. The key to that essential function is that you can define it, however narrowly.
All right, Mark, so let me interject one more time here so that we can flesh out what an essential function is. Let's say we've got someone who is responsible for procurement of paper clips, Post-it notes, and the like. Could that person be considered a function manager?
Absolutely. We're a law firm, and stationery is critical to what we do. So in our case, the person who's procuring those supplies is essential to the way we operate. That brings us to the L1B, the specialized knowledge employee, which we'll look at in much more detail later, but who has either special knowledge of the organization's products or services and their application in international markets, or an advanced level of knowledge or expertise of the organization's processes and procedures. Note that these are subjective and often uncertain definitions, and so adjudication can seem a little arbitrary, particularly for executives, function managers, and specialized knowledge employees. So we'll look at the issues and how to overcome them a little later on. Looking at my next slide, which is advantages, if we have these issues, why do we want to use the L1 visa? Lots of compelling reasons. Firstly, there's no quota. We all know at this point, I believe, the issues we're facing with the rapidly disappearing H-1B. There's no quota on L1. There's no annual limit. You can use them as often as you need as long as the employees and organizations qualify. There are no prevailing wage obligations, which keeps the Department of Labor out of the filing. This is great because that's one less layer of scrutiny from a government agency. It's one less timeline to monitor. And unlike H-1Bs, L1s now are being processed with no issue despite the government shutdown, which is affecting the Department of Labor. And apropos of the prevailing wage issue, your transferees can remain on your home country payroll. So for you in the HR community, this is a huge plus. They can keep their home country salary and benefits, and they don't have to be effectively expatriated to the U.S. in the course of the transfer. Big asset, we know, in the context of international relocation. Spousal work authorization is permitted. This is a major one which H-1Bs do not get. And a last very important one is that when both the foreign and U.S. roles are managerial, the transferee manager is on a fast track to a green card if you opt to sponsor him or her. That means no perm process. That overwhelming and burdensome Department of Labor market test is totally skipped, and they're not affected by the backlog that is currently a burden on so many employees who are waiting in what we call retrogression to become current. They go directly to the approvable level of adjudication. Tangentially, it's also worth noting that transferees don't have to come to the U.S. to do the same work they did abroad. So you can also look at someone who's being promoted into the U.S. from a hands-on contributor role, and by the same token, they can use them for short-term projects and intermittent assignments, such as a manager who may need to be in the U.S. for a week, a month to supervise a team here, but that's all that he or she is looking at. The L1 is the optimal visa for these scenarios and will work perfectly in this regard.
Well, thanks so much, Mark. I think it would be appropriate now to touch upon two additional advantages, if you will, of the L1 program. One is an option that's available to smaller foreign companies wishing to start a new office in the U.S., and the other is available to large multinational corporations. So, Maria, could you please guide us through these?
Yes, thank you, Phil. Thank you, Mark, and thank you to all of the participants on the call today. I'm going to be talking about two very neat little programs that the Immigration Service affords to companies. The first one we're going to talk about is the New Office L1 petition. It is a program that allows either startups or smaller multinational companies overseas who wish to establish a company in the United States to be able to transfer their employees from overseas into the U.S. The rules ask that the U.S. employer must be doing some business in the U.S. for less than a year, so a newly established company would qualify. However, please note that a mere presence in the U.S. is not sufficient. In order to apply for the New Office L1, the company in the U.S. will need to provide information that typically would not be required of L1s. The sample listing we have here on the slide are some evidentiary features that you would need to have when you submit the L1 petition for a new office. It is recommended that you have a lease to either a facility or to offices, and that lease should be at least a year or so in length. You will need to show that the new company will be able to support either the executive or the manager you're transferring within that 12-month period requested on the petition. So you need to take a look at the size of the monies that the U.S. employer will have and the financial ability of the parent company to be able to pay the salaries of the transferee and also to, of course, conduct business in the United States. Therefore, Gibney typically will recommend that you have a detailed business plan submitted with the petition, and that business plan should spell out the projections of growth, staffing, and revenue. You want to show immigration how and in which ways you will grow this business in this one-year period. You must, of course, still show that the transferee coming from overseas has that 1 year of qualifying experience that Mark talked about. Please note that the new Office L1 petition is limited to 1 year. Therefore, immigration will issue the approval and give you 12 months from the date of approval for the activities to go on during that year. As it comes to the end of the first year, you want to take a look at your extension and the petition. Immigration will allow you to ask for a 2-year period at the time of the extension, but unfortunately it's not the easiest of processes. The extension is going to be one that you as a company will need to document the growth of the operations, the activity. Typically, we recommend that U.S. employers have handy at the time of the extension a report of the sales or the cash flow or a listing of the clients, any contracts that have been undertaken during that 1-year period.
Maria, if I can interject for a minute here, is there a way for the government to check and see if the new office is actually operating?
Yes, Phil. Actually, immigration has in the past few years been utilizing a tool called the VIBE system, V-I-B-E, which is a validation instrument for business enterprises. It's a web-based tool used by the Immigration Service to review the corporate information. And in fact, VIBE, the information in VIBE is data provided by Dun & Bradstreet, a DMB provider for the government, and they are putting in data like the corporate information, FEIN number, the activities, the revenues. That kind of information is in that system, and we typically will recommend to companies, especially in this scenario, the new office, L1, that they update and monitor their DMB profile so that it is as up-to-date as possible and will be reviewed by immigration, both at the initial stage of the petition submission and, of course, at the time of the extension.
Okay, great. Thanks so much, Maria.
Thank you, Phil. Okay, now I want to talk about the other program that exists. It is a very advantageous program that large multinational companies can utilize when transferring from overseas. It's a special program that facilitates the transfers of individuals by having the U.S. employer get a pre-approval of the required qualifying corporate relationships, the ones that Mark discussed earlier. So the U.S. employer would file a petition with the Immigration Service, and if approved, they would get a blanket approval, and attached to that would be all of the qualifying organizations across the world. The 3 main requirements are listed on our slide here. You need to be able to show that the U.S. or the overseas company is in fact engaged in commercial trade or services for 1 or more years. It must also show that they have 3+ domestic foreign branches, subsidiaries or affiliates. And here you have to show either U.S. sales of $25 million, or that you have a workforce of 1,000 U.S. employees, or that you have actually used the L1 and have had 10 L1s in the past 12-month period right before you submit the blanket petition. It's all done here in the United States, and once the U.S. approves the L1 blanket, the approval can then be sent directly overseas to your employees, and they can go right into the U.S. consulate and apply for the L1 stamp. There would be no need for an individual L1 petition. So naturally it saves quite a bit of time, effort, the filing fees, and it's a fantastic tool if you quickly need to bring someone in within days of identifying that transferee. You can have them in the U.S. if you have an L1 blanket approval. The L1 blanket is issued for a 3-year period by the USCIS, and at or close to the end of the 3 years, you can file an extension and receive an indefinite approval, meaning that the service will approve it indefinitely and allow you to use that blanket through the course of the existence of the companies. However, the extension needs to be documented by showing, of course, the requirements we list above, plus a report of usage. So at the time of that extension, you must be able to show that you have had L1s under the blanket, and you need to list them in a report submitted at the same time of the extension. Also, take note, you cannot just receive your indefinite extension and have it remain a static document. You must continuously monitor and review it periodically for any changes, update those changes, which would or may require an amendment to be filed of the blanket petition with the Immigration Service.
Okay, great. Thanks very much, Maria. Now that we have the basic framework under our belt, I think it's time to delve into the challenges we're seeing on the ground. So back to Mark. What are the challenges you're seeing on the L1A front?
Well, Phil, the major issue for the L1A is a heightened degree of agency skepticism about whether the employee truly rises to what they perceive as the level of an executive or a manager. This comes partly from the arbitrariness of some of the definitions and the uncertainty, but also because of the benefits, general L1 benefits that we've talked about, such as the absence of any numerical cap, no Department of Labor involvement, and the availability of spousal employment, all of which make it more attractive than the H-1B. And of course, for the L1A manager qualifies the fast track to a green card. So there's major incentive for people to try and use the L1A whenever possible, and the agencies are very alive to this possibility. In terms of staff, they're looking at whom you consider reports, and staff for our purposes will include only managerial and professional subordinates who are actual employees of the organization. Now, this can mean that, for instance, if your company uses a follow-the-sun model and the manager has reports located around the world but not locally, if they roll up to him or her in terms of their personnel actions, those are managers and will count as staff for purposes of managers. However, on-site consultants who may be at the adjacent desks, if they're placed there by vendors with whom your company has a contract, then that manager doesn't have full personnel authority over them. And they would better be classified as function managers because they're not actually staff for L1A purposes.
Okay, Mark, just quickly though, can you expand upon what it means to have to manage professional employees?
Absolutely. Professionals in this context includes the same category of workers that are used in the H-1B definition, essentially, which is what we would think of as white-collar employees, people who are in fields where at least an undergraduate degree is a requirement for entry to the profession. Now, this is very important because you may have someone who manages a flat structure of clerical or technical or administrative people, perhaps dozens or even hundreds, but they do not rise to the level of staff management for purposes of this classification. So beware of that. Now, if that manager has a multi-tiered structure with managers under him or her who in turn manage non-professionals, that's okay because that manager has managers reporting in. The function manager is even harder to prove because what is an essential function? Consular officers may challenge insufficiently prepared employees in the blanket process at interview about whether they truly manage an essential function. And immigration may issue very complex and detailed RFEs, the requests for evidence that Philomena mentioned in the outset of our presentation, where they may ask for huge amounts of information about the duties of the role, the duties of the peers of that manager, the duties of subordinates, of supervisors. In many cases, these are extensive fishing expeditions because immigration isn't really sure whether or not this person counts, and they want to try and establish that they're not really sole contributors who are trying to squeeze themselves into the highly desirable L1A category. In terms of resolving it, the answer to that is, of course, that you, the company, know the job better than the agencies do. And so presenting it in a way that makes the case and gets over their concerns initially is going to be the surest way to success. Looking at executives, the problem there is that they're defined differently only in that they direct as opposed to managing. in the organization. That's a highly uncertain distinction, and even the officers don't always know what it means. All they know is they're looking for a very high bar. So as a recommendation, we always suggest avoid the executive classification. All executives are part of senior management, so just go with the lower bar and use the manager. Now, when you're working with manager cases, the key is the extent and level of discretionary authority they wield. Budget, staffing, timelines, deliverables, quality control, all of these things, to the extent they come under that manager's purview, are going to build your case for their having extensive independent decision-making authority over the area of operations that they manage. With your most senior staff, the ones who might rise to the level of executive if we were going to go there, a significant downward reporting structure is a very helpful tool, as are impressive titles and very high levels of compensation. These may not sound legally sophisticated, but the agencies can be a little bit simplistic in their approach, and they do like to see shiny, glittery things, like important titles and large numbers. Similarly, with a function manager, the more substantial it looks, the better it's going to be. For instance, you may have a CFO in your organization who has no direct staff reports. That's fine. He or she clearly manages an extremely important function. Now, for staff managers who may be at a more of a mid-tier level, very importantly, we always believe in organizational charts, and the agencies like visuals. Even one managerial or subordinate report will count, but so will upward reporting, because if they report into very senior people, that will help to bolster the case that they in turn are senior. For function managers, the key to dealing with the uncertainty on the part of the officers is to be very clear in defining the nature of the function in detail and why it's essential to the organization's operation. Even again, as we said, if it's a narrow definition and a narrow function. This is critical for blanket applicants. Prepare them well. They need to understand why they're function managers when they go in, because the commonest phenomenon is an officer says, "Are you a manager?" And they fall back to thinking on staff issues, saying, "I'm not, because I don't have staff," as many of us do view staff managers as being managers, and then they get denied. But if the function is clearly explained to them, they'll get it. And a case in point is I worked with the editor of an in-house weekly periodical that was circulated throughout his department. And he came to me and said, "Well, I'm not a manager. Nobody reports to me." But as it turned out, this periodical was read by the whole department as soon as it came out each week for the information that it contained, and they considered it critical. So it was essential to the organization. And he had full discretion over what stories went in, who wrote them, what was included and what was excluded. So by the end of the discussion, he was comfortable, which was important for his interview, and I was comfortable, that we had established him as a function manager within the definitions. So those are basically the issues that we typically see in connection with L1A filings and how we address them. The L1B presents a very different set of challenges, and I'm going to turn it over to Maria again now to discuss those.
Great. Thank you, Mark. Okay, the L1B, the primary challenge is unfortunately due to the moving target that we have to work with, and that is the definition of specialized knowledge. The USCIS regulations and statute very clearly define it. However, the agencies, either the USCIS or the Department of State through the consular officers at the blanket time, or even individual L1Bs, will apply a definition that is outside the scope of the law and the regulations as they exist. Some examples of what the agencies are looking at are on our slide here. I'll just touch upon some of them so that you can feel and understand the pain that we have to go through when preparing these L1Bs and how we can simplify it by explaining in great detail. You want to show primarily that the knowledge the individual is bringing from overseas is going to assist the company, whether it's the U.S. or the foreign overseas company, be competitive in the market. and that the knowledge that they're going to apply will contribute to the operations internationally, so that the knowledge is is going to be not used only for the foreign company or for the U.S. company, but it's going to help the global operations of the multinational company. You want to make sure you explain that the individual transferee is a key employee. And what makes someone a key employee is really based on the length of time that they have spent overseas with the company and the experiences that they have acquired with that company. The complexity of what they deal with is now going to be brought over to the United States. Also, key words that we have seen lately are that the knowledge that the individual is going to apply in the U.S. and bring over is uncommon. It is not typically found in the industry, so you need to be able to show this because this has been an ongoing battle, shall we say, in showing that this L1B has this specialized knowledge. Also, you can explain that the knowledge that the person is bringing from overseas is not easily or quickly transferred to the to a U.S. employee. It comes down to how much would it cost if you can show economic burden to the U.S. employer in trying to train those that are here on the ground. That will also help in explaining the specialized knowledge. And one of the challenges we face also is when you bring someone who is a relatively new employee from overseas, someone who's had maybe 1 year or 18 months at the company, but yet they possess a very specialized knowledge in a particular area, whether it be a system or a product. You want to be able to explain that despite the short time that they have been with the overseas employer, they still do in fact possess that specialized knowledge. So other challenges we see are on our next slide here. There is the ability to bring over employees and have them at third-party work sites, but they are very carefully scrutinized by the agencies, and while they permit them, they do want to see the essential element, which is show that the L1B employer does in fact have control over the transferee. So it's not the transferor company, the foreign overseas company that controls them, but actually the L1B employer here in the United States. So that is an issue that we want to carefully document, and we'll go through the tips in a moment. And the challenges continue both in the L1A and the L1B, but because of the fraud that they have seen, there's a high level of suspicion, and it's primarily due to the ambiguous definition of specialized knowledge. As you saw in the prior slide, there are so many ways to look at what is specialized knowledge that we have unfortunately seen an increase in the RFEs, the ones that Phil talked about, and the dramatic increase we've seen over the last few years. And that also has also led to denials at the consular level, especially in certain jurisdictions. They suspect that the L1B specialized knowledge is really not anyone but a technical person coming over here, and they will look at them very carefully. Additionally, we have seen, and we will probably see more once the government is operating and funded, they will be conducting site visits of the L1B employees here in the U.S., and the consular officers may in fact also be visiting some of the foreign operations. Other challenges we've seen come when the individual is already here in the U.S. and they've only been given a 5-year period of time with their L1B, but there may be a need for that person to remain for longer periods, or there may have been a change in the role the person is filling when they first arrive to when they, after the 5 years, and we recommend you look at in the 4th year so that you have enough time to change them over to an L1A. There is a rule that you need to be careful and mindful of, and that is you cannot change them in the 6 months prior to the 5th year of the expiration. So you want to take a look at them again in that 4-year period time frame so you have enough time to change them over. And lastly, if in fact they remain here on L-1B and you want to have them remain indefinitely in the United States, you cannot fast-track an L-1B. They must go through the labor market test and file those horrific PERM applications and have the Department of Labor involved in that process. So that is a major challenge of the L-1B. So how do we deal with all of these challenges? On this slide that we've given to you, we give you some recommended evidence so that you can document that specialized knowledge. It's always a good idea, again, as Mark alluded to provide visuals. You want to give the Immigration Service any either presentation or a PowerPoint or a report that gives a detailed description of what the person is working on, whether it be a product or a service, so that it will show the complexity of the particular specialized knowledge being applied. You can always show the record usage of your key employees, very helpful in the IT world to show who you've transferred over in the past few years that have actually had the specialized knowledge. It would be also a very good idea to provide a letter or an explanation of why it would be so difficult and the great economic burden it would be to the U.S. employer if you were to train a U.S. employee and not bring over that L-1B specialized knowledge individual. The others there are also helpful tips or recommended evidence that you can use. In the world of third-party placements, you can bring them over here, but you need to be very careful in documenting the control that the L-1B employer will have over that transferee. So you might want to include any status reports or projects which are going to be reviewed directly by the L-1B employer. And I think those are the major tips for us from right now.
Okay, great. Thanks so much, Maria, and thanks again, Mark, for those tips. Another aspect of intracompany transfers that I think is definitely worth mentioning is what to do with family members. As many of our listeners may know, issues surrounding the family members of L-1 visa holders can often derail an international transfer. So, Mark, can you please walk us through how family members might be accommodated to accompany the L-1?
Well, Phil, prima facie, any L1 who has a spouse or child will be able to get some L2 visas automatically by demonstrating their legal relationship. And the L2 is the visa that's used for these derivative dependents. There's a big incentive, as we noted, for the L2 spouse in that they can work. And that is not true, as we noted, for H-1B spouses. Children who come in on the L2, however, cannot work. So for those of you bringing over senior people with teenagers, for instance, be mindful that though they may want to join their friends in a summer job in high school, not an opening that they can pursue. A very great note is that, of course, in June we had the important Supreme Court decision overturning the Defense of Marriage Act. And the federal government and the immigration agencies, to their credit, have moved quickly to implement parity for same-sex marriages where legally recognized and incorporate that into the purely federal immigration law practice. As a result, if same-sex partners who are married either in a country where that marriage is recognized or in a U.S. state where it's recognized, can now apply for L2 visas with the same privileges as an opposite-sex spouse, including the right to apply for work authorization. Do note, however, we know that many of you will be transferring people, often senior people, from countries that have established legal relationships that are tantamount to domestic partnerships or common law spouses, but don't rise to the level of a legal marriage. The U.S. draws a bright line between married and not married. Anyone who's not married, same-sex or opposite-sex, can only accompany the L1 on a modified version of the tourist visa, the B visa, which comes with many more restrictions and confers no right to apply for work authorization.
So Mark, just out of curiosity, have any of your clients ever decided to get married in order to obtain L2 work authorization?
Yes, Phil. I have in fact played unintentional marriage broker in several scenarios. Wasn't what I was expecting, but they ended up deciding that wedding bells were worth it for the benefits of the L2 visa.
And on a practical level, can an L2 spouse apply for that employment authorization document before arriving in the U.S.?
No, and we know that some spouses may be very eager to start work as soon as they arrive. But harking back to what I said earlier about you cannot apply for an immigration benefit before you're eligible, you can't apply for an employment authorization document or EAD card until the L2 spouse has affirmatively entered the U.S. in L2 status. Now, what benefits do children get? Well, as I noted, they can't actually work, but they automatically are entitled to attend school. And they are also considered children, in quotes, for dependent purposes for the visa until the age of 21, not the age of 18. This is a tremendous benefit because if you have a family with older kids and your company decides to sponsor the transferee for a green card, the kids can ride with that process and automatically receive the green card when it's approved for the employee up to the age of 21. But this is very important. So if you do have someone with older kids, please do the analysis immediately and consider starting the green card as soon as possible. Because at 21, if the process isn't well in hand, they will forfeit their dependent status and they will either have to leave the country or they will have to find independent visa status. As an incidental note, we do know that some senior people want to bring domestic staff with them. They can be brought over as well on a modified tourist visa, subject to restrictions, and unlike domestic spouses, they are entitled to apply to work here.
Great. Thanks so much, Mark. Now, before we make the shift over to global, I just want to make a few remarks about possible changes on the horizon for the L1 intracompany transfer. First, a recent report was released by the Office of Inspector General within the Department of Homeland Security, and this report takes a very close look at the L1 visa program and makes recommendations for quote-unquote improvements. The report recommends that new regulations be passed to clear up agency confusion on the definition of specialized knowledge. Now, on the one hand, this could be good because we'll have more clarity, but on the other, this could signal a more restrictive regulatory standard and or policy memoranda mandating a higher evidentiary standard. So that's something to monitor and be on the lookout for. The report also recommends consolidation of blanket adjudications and better screening and communication between the agencies to target fraud. Now, we've seen this happen already in India, where L1 blanket visa applications have been consolidated in Chennai. Now, this is somewhat positive in that it could signal more consistent L1 adjudications at the consulates abroad. But on the other hand, with increased agency communication, inconsistencies, even small inconsistencies between applications could be picked up and construed as fraud and trigger more denials. Finally, another recommendation that I thought was interesting that came out of the report was that it recommends that site visits be implemented before extending an L1 new office. And USCIS actually did agree to adopt this recommendation and implement it imminently. So again, something to look out for. In addition, I think comprehensive immigration reform might be on people's minds, among many other things that are happening in the government right now. And on the issue of CIR, which stands for Comprehensive Immigration Reform, my crystal ball is telling me that the outlook is somewhat hazy. There was a lot of momentum on CIR, but with Syria and now the government shutdown, it seems to have been pushed aside, even though we have seen the House actively debating this bill. All I'll say is this. Like the Department of Homeland Security, Congress is also looking closely at L1s. And based on its proposals, it plans to regulate the classification much more heavily. Again, this is due to a perceived threat of high fraud in this category. Therefore, some of the provisions proposed by CIR are increasing the L1 application fees, implementing a prevailing wage requirement, so that would be like the H-1B, and increasing prohibitions on off-site placement of L1 employees. CIR also proposes increased monitoring of the visa category coupled with new penalties, that would be financial penalties, for non-compliance. On the positive side, because there is a small positive side, L1 visa holders, and all visa holders for that matter, would not have to leave the U.S. to renew their visas. So this is referred to as visa revalidation in the U.S. and would make L1 visa renewals much more convenient and less expensive. So if anyone interested, listening here is interested in CIR, our website does post regular updates on this topic, even though right now the outlook is somewhat cloudy. Okay, so with that, let's turn to global. Deborah, how do other countries treat intracompany transferees?
Thanks, Phil. I would like to start by stating that the immigration laws of the host country govern business visas, work permits, and resident permit requirements. And all countries have different rules and regulations on who can enter and depart a country. Visa requirements may be impacted by treaties or other international trade agreements, such as the North America Free Trade Agreement, or member states of the European Union may provide immigration benefits to other EU countries. I think we all have heard at one time or another that a foreign national has said, my friend went through this work permit process and it was so easy. And it only took a few days, and why is my work permit different than my friend's? Well, in the old days, HR and global mobility professionals were just trying to understand the procedures, the requirements for obtaining a global visa in a specific country. But today, many countries have undergone comprehensive immigration reform, especially in the UK, India, the Netherlands, Mexico, and Canada. These countries have had significant changes to their immigration policies, and as a consequence, HR and global mobility professionals have had to try to keep up with the pace of these changes. Therefore, it is important for us as practitioners to prepare our clients and set expectations so HR and global mobility professionals can respond quickly when implementing all the changes. And the more communications that can be done up front will help to avoid significant delays in the overall work permit process. And the global recession has led to some inconsistent trends. There has been strict scrutiny by many countries when adjudicating work permit applications, as well as restrictive interpretations of these regulations with the aim of reducing the number of foreign nationals in a designated country, and also to protect the local labor market. Some example where this has occurred is in France, the United Kingdom again, Italy, Switzerland, Spain, Algeria, and Ireland. The visa category that is largely under attack, and is the topic for our webinar today, is the intercompany transfer. Not only are we seeing this in several EU countries, but it is also happening in the United States. Specifically, the government authorities are targeting employees assigned to third-party work sites because the government perceives that these jobs could be filled by their own country nationals. We are also seeing an emphasis on EMEA on attracting investors, entrepreneurs, and those foreign nationals with exceptional talent. Countries have been implementing new visa categories to attract highly skilled individuals to their countries and making a clear pathway for permanent residence so individuals can remain in their country for a longer period of time. And I wanted to also emphasize today some of the application procedures and requirement trends and to provide the general guidelines for the intercompany transfer in other countries. I will then discuss how the intercompany transfer works in the United Kingdom, Canada, Brazil, and Japan in order to give you a flavor of the various regions around the world where an intercompany transfer is a possible visa category. But before I get started, I wanted to point out that the documentation requirements for the intercompany transfer will vary by country, but the common document that is always required from the company is evidence of the corporate relationship between the home and the host country, just like we heard from the U.S. team when they discussed the U.S. L visa. The processing time for intercompany transfers for each country varies. For example, in Canada, at a port of entry application will take 1 day or process upon entry into Canada. In Japan, the processing time for an intercompany transfer can take up to 3 months for newly established entities. And in Spain, intercompany transfer applications can take 8 months or more. Some countries will have restrictions on travel while a work permit application is pending, and other countries will allow you to travel to the host country and change status from business to employment visa while remaining in country, for example, in Australia and Singapore. In addition, the application procedures vary by country, as some countries require all the procedures for the application be completed in the home country, such as India and Germany, and other countries require that all of the procedures be completed in the host country, for example, in Australia and Singapore. There are countries that have a combination of the process where part of the procedure is done in the host country and part of the process is completed in the home country, for example, the United Kingdom and Japan. And unlike the United States, most countries require that the foreign national register with the government authorities once you arrive in country in order to get a resident permit. This registration process is part of the immigration requirements and must be completed in order to be fully compliant. One of the critical considerations when planning an overseas assignment is whether a spouse can work. Well, the general rule is a dependent spouse is not authorized to work and must find their own independent employer to sponsor an employment visa. Also, Turkey is one of the strictest countries, and spouses are barred from employment visas. The good news is there are several countries that permit spousal employment, such as the United States for the L visa, the United Kingdom, the Netherlands, Hong Kong, Argentina, Canada, Malaysia, New Zealand, and Australia also allow for spouses to work as a derivative visa holder.
Okay, Deborah, if I could interject, do you know if some countries recognize common law marriage or cohabitating partners for derivative status?
Yes, they do, Phil. There are a number of countries that recognize common law marriages and permit unmarried partners to obtain immigration benefits, and these countries include Canada, the United Kingdom, Australia, South Africa, New Zealand, Brazil, and Argentina. And importantly, the partners granted an open work permit for the validity of the partner's period of stay. And there also are a few countries that treat same-sex partners the same as non-married heterosexual couples and provide derivative status. These countries include the United Kingdom, Canada, Spain, Mexico, Norway, Sweden, Iceland, Portugal, Argentina, South Africa, and Brazil. And cohabitating common law partners as well as same-sex partners will need to provide evidence that they have a bona fide long-term relationship to be eligible for derivative status. And typically, they must provide evidence that they have lived together for over 1 year, have children, hold joint property, and hold various investments together.
Great. Well, thank you so much for that general overview, Deborah. Would you mind now touching upon some of the specific country requirements on intracompany transfers?
Sure. The United Kingdom has, I'll start with the United Kingdom, and the United Kingdom has undergone comprehensive immigration reform, and there have been ongoing changes since 2008 when the UK Border Agency announced the move to a point-based system. The UK BA continues to make changes in the UK immigration regime with a goal to significantly reduce migration. The intercompany transfer in the UK falls under the Tier 2 category, and the UK Border Agency requires that the UK employer have a valid sponsorship license in order to issue a certificate of sponsorship or cause for each employee. The Tier 2 intercompany transfer requires there be a direct corporate relationship with a UK company and the foreign affiliate. The employee must be in an occupation on the graduate occupation list, and the employee must have a direct work experience with an affiliate company immediately prior to the transfer to the UK. The UK has now set a minimum salary requirement for the intercompany transfer, which the employee must meet depending on the Tier 2 intercompany transfer subcategory. And to qualify for the Tier 2 intercompany transfer, their employer must be at a minimum of 70 points. And on the screen, I've identified how the points are allocated in order for the applicant to be issued a certificate of sponsorship in the UK and meet the 70-point requirement. In summary, the intercompany transfer category in the UK has 2 great benefits. The first being that it's not subject to the annual quota of 20,700, and the second benefit is that a university degree is not required. There are also 2 drawbacks to the intercompany transfer category in the UK, as there's 1-year home resident requirement, or what the UK call a cooling off period. And secondly, the UK Border Agency now restricts the intercompany to a maximum period of 5 years.
Deborah, does the Tier 2 intracompany work category provide a pathway to permanent residence in the UK?
So I'm glad you asked that question because the intercompany transfer used to be the best and the quickest work permit category to obtain. And if an employee came to the UK as an intercompany transfer and remained in the country for 5 years, the employee was eligible for permanent residence. But now the UK Border Agency implemented this cooling off period, which required the employee to leave the UK at the end of the 5-year period of time, and they would not be able to return to the UK for 1 year. Therefore, it is important to plan ahead and make additional time up front to strategize what the goals of the employer and the employee are with regard to the employee's assignment in the UK, especially if the goal is to transfer the employee for an indefinite period of time. If this is the case, it would be better to take the additional time it takes for recruitment and file under what's called the Tier 2 General category, because the Tier 2 General does not allow for employee to apply for permanent residence after a 5-year period, and your employee would be able to stay in the UK indefinitely. Next, moving into the Americas, and starting with Canada's intercompany transfers, which essentially have the same requirements as the U.S. does for the L1 visa, as it requires that an employee must be an executive, manager, or a specialized knowledge position. The employee must have been employed by the qualifying affiliate in a similar position for 1 year in the previous 3 years prior to entering Canada. And last year, Citizenship and Immigration Canada added an additional requirement: the employee must be actively employed by the overseas entity at the time the work permit is filed. In Canada, the employee must be granted an initial 3-year period as the intercompany transfer, and the work permit may be extended in 2-year increments. And then heading next into Brazil. Brazil has several different criteria for their intercompany transfers, as they have what's called a 2-for-1 rule, which means that for every foreign national, there must be 2 Brazilian employees. This rule requires that the Brazilian entity must demonstrate that the intercompany transfer salary must equal or exceed that of the company's highest paid employee with the same duties. The employee must also be placed on the Brazilian payroll.
Deborah, how would a company document that it meets the 2-for-1 rule?
Well, the government authorities in Brazil generally want to see the entire Brazil payroll for the corporate entity in Brazil to determine whether the applicant's salary meets the 2-for-1 rule. The 2-for-1 rule requirement is difficult for many companies to prove, especially for startup companies moving into Brazil. So we generally look at alternative visa categories at the onset of a case to determine if the work contract visa is more suitable to meet the client's needs. In addition, the qualifications for a Brazilian intercompany transfer requires the employee hold a university degree or 9 years of formal education and 2 years of relevant experience. The employee must be contractually employed by the Brazilian entity and provide an employment contract. Importantly, a recent change now allows employees to file a permanent residence after a 2-year period of stay, which is a great benefit for long-term assignees in Brazil. And the last example of an intercompany transfer in the APAC region is Japan. Japan's intercompany transfer is very similar again to the U.S. L1 visa, as employees must be in an executive, manager, or in a specialized knowledge position. The employee must have been employed by the qualifying affiliate in a similar position for a 1-year period. And one of the differences in Japan's requirements for the intercompany transfer is that if the employee does not have a university degree, they must have 10 years of experience in a field directly related to the proposed position. And there has been a recent change in Japan for intercompany transfer, which in the past was limited to a maximum cap of 5 years, but now intercompany transfers can be extended indefinitely. This is a great benefit also for companies transferring their employees on a long-term assignment to Japan. So in summary, many countries do have an intercompany transfer visa category, and generally the intercompany transfer is a great category for your employees, but do check each country's requirements in order to see if there's any restrictions existing that could impact your employees. So back to you, Phil.
Great. Thank you so much, Deborah, for that whirlwind tour, and thanks to all of today's speakers. You've all done a great job of highlighting the challenges facing intracompany transfers and tips for surmounting those challenges. So we did receive quite a few questions, and we promised to respond to them all via email. I think we only have time to answer one. on the air right now. So I'll take one, and the question is, when applying for a green card for an L1 who was a manager in both foreign and U.S. roles, is there a length of time that the manager must have been the foreign manager? And there's a second part, and do we need to apply within a certain time frame after the manager comes to the U.S. on the L1? Sure, I'll turn that over to Mark. Why don't you answer that?
Sure.
Thank you.
The answer to that two-part question is the L1 qualification, as always, is 1 full year. So as long as you can demonstrate that the manager overseas was a manager during a full year with the overseas organization before coming to the U.S., then they meet the basic overseas qualification. In terms of when you apply for them in the U.S. for the green card, the answer is really whenever it suits your company policies and the approach that you want to take. They remain eligible as long as you're sponsoring them for a managerial role in the U.S. any time during those 7 years for which they would be theoretically eligible. I hope that answers the question for you.
Yeah, so it basically mirrors, the green card process mirrors the L1 process.
Correct.
You need that 1 year of employment abroad and then need to be in a managerial role here in the U.S., and it can happen at any time. There is no time frame. All right, well that, I think we'll have to sign off now. I thank everyone for joining us today. We really do appreciate your time, and have a great day. Thanks very much.